So state content review. This is going to be the highlights. We're going to try to get this done in 35 minutes. Let's get into page 4. On this page, the number one thing I think you need to know is the mission of the Real Estate Commission is to protect the public. Not you as an agent, but protect the public. They might ask it in a way that's something like, how do they protect the public? Well, they do it by having licensing standards. They do it by having disciplinary standards. They do it by having license maintenance standards. Page 5. It reviews when you need to have a real estate license. These are the exclusions of a time that you can do real estate and not have a license. Number 1, you're selling your own property. Number 2, you're a power of attorney. And then the third one I had you highlight is actually number 8. You're the resident manager who lives on the premises. You're a resident property manager that lives on premises. Page 6, getting a salesperson's license. Number 1, you cannot apply for an inactive license. You've got to work under a broker. You've got to have a broker named when you apply for your license. You've got to be 18 at the time of application, not 21. There's nothing here that says high school diploma or equivalent. You've got to be 18 years of age at the time of application. Then that bullet point that talks about citizenship is not a reason to deny a license, but it might be asked for on the application. I would know that bullet point as well. Then at the very bottom, it states that all licenses are issued for 3 years. The first year counts as a full year, and all licenses expire December 31st. We're going to tack on some more information with that one as well. The other thing I had you add to your notes is when you apply for your salesperson's license, you must apply by the last day of the 6th calendar month after you pass the exam. After you pass the exam, you must apply for your license. The deadline is the last day of the 6th calendar month. Broker application on page 7. We know 18 years of age or older. The citizenship note is the same. Licenses are 3-year renewal. The first year counts as a full year. We know December 31st is the deadline. What's unique about the broker that I want you to know is number 1, they've got to do 60 hours of pre-broker education. And number 2, they've got to be actively licensed for 24 months. That equals 2 years. There's no requirement for volume or number of transactions. For license maintenance and renewal, you've got to do 36 hours of continuing education every 3 years. A reminder, as of right now, if you get permission from the Real Estate Commission, you can take the real estate exam in lieu of the CEs. Of the CEs, now we're at the top of page 8, that is made up of 24 electives, 8 law update, and 4 ethics. Law and ethics are mandatory. The other 24 electives you can do of your choice. And then I'm going to update this for you, even though I don't know that it will be on the exam yet. This law was just passed July 1st, 2025. The law states that you can have carryover CEs to your next renewal period. So if you crank out a bunch of CEs, you can carry them over to your next renewal period. 18 hours can be carried over, excluding mandatory hours. So if you did 44 electives, That would cover the 24 that you need for this renewal period, and then you could roll over 18 of the remainder to the next renewal period. Renewal requirements, page 8. If you fail to renew your license, the law says there's a 30-day grace period to January 30th. I would know the 30-day grace period to January 30th. I would also know what the grace period is. The grace isn't that you get to keep selling real estate. No, your license is inactive. The grace is you don't have to immediately start from scratch and do this class and a new application. That's the grace. The third thing I want you to know from this section is that grace period comes with a $25 fine. Then on the top of page 9, you can pay that $25 a month fine for up to 3 years. If after that 3 years you are not reinstated, after that, then you've got to start. That's when you've got to start from scratch. Anytime your license is active, you've got to have E&O insurance. Let's go to disciplinary actions. I had you review some things that could get you in trouble with the real estate commission. But where I think the real goody lies is on page 14 in the middle. If they do their investigation and they deem that there is a chance that you are guilty or you are guilty, but they need to determine how they're going to discipline you, that hearing, they've got to give you a 20-day notice. 20-day notice. Then you've got 10 days to reply to it. I added that for you, but I would know that 20-day hearing period. Then under disciplinary sanctions, the bottom of page 14, I would review the things they could do to discipline you. Suspend or revoke, pretty obvious. Additional education, the top of page 15, that's a good one to know. The other one that stands out that a lot of people miss is they can order a physical or mental examination with periodic reports. Then I think you'll have an additional question that's going to challenge you to know the maximum civil penalty for a disciplinary action, which is $2,500. They're going to trick you into thinking it's $5,000. It's not. It's $2,500. Then the other thing I would consider are the factors when they're disciplining you. When was your last disciplinary action? Was it for the same thing? Is it a repeat offender? What was your monetary gain? Was it intentional? I would review that list. Again, the bottom half of page 15. Tying agreements. We talked about this with antitrust law violations, that we cannot tie two contracts together. People can buy with you, people can sell with you as their agent, but we cannot tie those two together and make one a condition or a requirement of the other. We've got to allow those contracts to be two separate decisions for the client. You could have a question about that on the state and or the national too. Let's go to trust accounts. Page 20. In the middle there, we know it's got to be an FDIC interest-bearing account, and it's got to have the word trust in it. The third thing I want you to know is the interest made on that trust account gets transferred to the state on a quarterly basis. Under trust account maintenance, we've got to have trust deposits, these earnest money or security deposits, We've got 5 banking or business days to deposit those once we receive them. The top of page 21, I want you to know the broker can have up to $1,000 of their own money in a trust account. Now, we know commingling and conversion's illegal between a regular account and a trust account, or an escrow account is another name for it. But Iowa allows $1,000 in a broker's trust account just for bank expenses. We cannot open an account with $0. We cannot maintain an account with $0, plus any banking fees that you might get charged. We need a little cushion. When we released trust funds, it's got to be in writing, either on the original contract, or if that contract is not going to close, then we need an authorization written by buyer and seller, tenant or landlord, on how to release that money. Clients have got to decide, because at the top of page 22, we can never use earnest money as a way to cover commissions. And the only time that we can release earnest money is we had a deposit and the seller never accepted the offer. Now, there's more to the code about what your broker can do with unclaimed earnest money, meaning the buyer and seller never made a decision. There is more law to that. I don't have it for you in here because I've not seen it on your salesperson exam, but know that at some point, we can't just have money sit there forever. So get your clients taken care of in the moment. Page 22 under closing transactions. Mandatory for every broker to deliver to the seller at the time a transaction is consummated, is what I'm trying to say. A complete detailed statement showing all the disbursements handled by the broker. That's like a closing statement. We've got to keep trust account records for 5 years. Earnest money is either a cash or cashable check circumstance. It's got to be cash or immediately cashable check. If it's going to be a personal item like a diamond ring, that's got to be disclosed with the original offer and accepted by the seller. You've got 3 test questions on this section. You've got 6 or 7 maybe options I gave you for example things they could test you on. Agency. We've got to be providing agency prior to providing specific assistance. So before we can market a seller's property, it's got to be signed. For buyers, it's before we show property. It's got to be signed. That's for residential property, by the way. Page 25 in the middle, we've got to disclose dual agency. I would absolutely anticipate a question or 2 about confidential information on page 26. Obviously letting a seller know that the buyer would pay more or that a buyer would pay less. If it's the reverse, those are 2 top things I would keep in mind for the exam. Page 27, 28, 29, single and dual agency. Number one thing, we've got to present all offers no matter what. We've got to present all offers no matter what. And then the law says in a timely manner. That's my number 1 rule of Real Estate Fight Club. And then the other big thing I think you'll be tested on, and I'm doing just highlights here, so I'm giving you the high of the highlights. Page 31, it says you can represent yourself or immediate family. You can represent yourself or immediate family, but you've got to disclose it to all parties. So that would be agent is related to seller, agent is related to buyer, or agent is licensed in Iowa. Under contracts, page 33, there at the bottom, in order to market a property, we've got to have a signed listing agreement. None of this, I know a guy. None of this, I might have one coming up. You've got to have a signed listing agreement to market property. The other layer of that is you cannot sell, assign, or inherit listings when a broker dies. You die as a salesperson, that has nothing to do with it. We'll just appoint another agent. You thought I was going to say no one cares. No, I only say it like that to get your attention. Of course we care, but you're an appointed agent. So if you do pass, the broker is just going to appoint someone else. So if the broker or the client dies, these agency agreements die as well. We can't receive a commission outside of closing. You get offered a bonus, you can't take it. Unless it's documented and the check is written to your broker. But I, Amy Schaefer, cannot accept bonuses, cash or check from a client. It's got to be documented and written to my brokerage, Amy Schaefer Real Estate. Who needs a copy of documents? Top of page 35. My easiest way to say this is if they sign it, they need a copy. If they sign it, they need a copy of it. A buyer doesn't sign a listing agreement, they don't need a copy of it. A seller doesn't sign a buyer agency agreement, they don't need a copy of it. Buyer and seller sign a purchase agreement or a lease, they both need a copy of it. Listing brokerage agreements, as of right now, automatic extension agreements are illegal. And then the key thing that I think you could be asked multiple times: when can you approach someone with an exclusive agency agreement? Buyer or seller can't. You can't do it unless they approach you first. An open listing is the exception, because the whole purpose of an open listing is that they hire multiple agents. You can approach them at any time. Then I would know how to enforce a broker protection clause. Number one, the clause has got to be in the original listing agreement. Number two, it's got to be for a set period of time. And number three, the list of buyers that you're protecting has to be given to the seller prior to expiration. Pre-disclosures. Page 37. We know that material adverse facts, also known as latent defects, those get disclosed no matter what. We also know when that disclosure must be made available. It's prior to the buyer writing an offer or a seller accepting it. That same phrasing works with the lead-based paint disclosure. We also learned on page 38 that any repairs must be disclosed. So not if you fix it, if it's a problem in the past, but you fixed it, you still got to disclose it. And if the property condition changes, we need to update the disclosure, which means if you need to add an extra page, you add an extra page. Then at the bottom of page 40, I would know the exclusions. A property disclosure of residential property is for 1 to 4 units. Condo, townhome, single family home, duplex, triplex, quadplex. 5 or more does not require the residential property disclosure. The other two exclusions I would look for is power of an attorney, power of attorney, or the executor of an estate. I'm giving you word salad today, aren't I? I'm going to crank through it for you. Then those groundwater hazard statements, just in case this is still on the exam, I would know what is on a groundwater hazard statement. That's my GW Bush acronym. Groundwater, wells, burial sites, underground storage, sewer systems, and hazardous waste. I would know who can sign it. That's transfer or agent. When must it be made available? That's number 3 on page 41. It must be made available in order to record the deed. It doesn't prevent title from passing. The problem is we can't record it on public record. And if you're getting a mortgage, your lender wants it recorded immediately so they can put a lien against the property. And number 4, if an item is disclosed as present on this groundwater hazard, that isn't a requirement to repair. This is a disclosure that we use with the DNR. Any repairs should have been negotiated as a part of the original agreement or with a home inspection. Broker responsibilities. Page 43. This says that a brokerage needs a licensed broker, a managing broker in that office, but it does not need a managing broker for all the affiliate offices. That one license will do. 72 hours to return a license. And if a broker loses their license, they can't complete a closing. All of the licenses underneath them are now inactive as well. Thanks. We talked a lot about that this morning. Bottom of page 44. Broker is required to provide a progress report upon request. There's no 5-day, 10-day, 30-day increment. It's upon request. Middle of page 45 states that the broker is ultimately responsible for everyone, licensed and unlicensed, that they hire, or any third-party vendors. We're going to add on to that a little bit here. Again, this restates that if there's a dispute over compensation or commission dollars that might have been shared between brokers, you got to figure that out amongst yourselves. The real estate commission, they're not there to protect us. They're there to protect the public. Top of page 46, I would know that that's a 10-day window to remove any advertising when a brokerage closes. Top of page 47, I would know those 4 A, B, C, D elements at the top that are required with all of our advertising. Your full name, the broker's full name, the city and state where you're located, and where you hold a license. Again, I'm Amy Schaefer Real Estate, West Des Moines, Iowa, licensed in Iowa. You don't need your license number. Then under support personnel, I absolutely think you should review prohibited and permitted activities. That's page 48 and 49. Back to page 47 though, under support personnel. We just learned that the broker is responsible for everyone. But what happens if one of the salesperson's license or licensees hires an assistant? This says the broker is still responsible, but the agent that hired it has the utmost amount of responsibility. If you get this question on the exam, it should be written almost verbatim to what the code is here in the handout. Property management, page 50. I would review what's in a property management agreement. Do they have access to bank accounts? What responsibility for bills do they have? How often are they getting paid? According to the law, a property manager should get paid a minimum of 1 month unless the contract says otherwise. So I would review this list. The other two questions there's two in this section, but the other two that I think are probable is if you do have permission to manage finances out of an owner's bank account, that's a part of the original property management agreement. We cannot write checks that would not clear the account. So don't get bouncy with any checks. The other layer is if you do write checks that require you to transfer money between one or more bank accounts, you got to have billings and receipts. You can't just do it on a ledger and cook the books. The other layer is if your property management agreement ends, you're required to give the tenants notice about who their new contact is and where their security deposits will now be located. And then that Iowa Civil Rights of 1965, just don't get confused by the date. Iowa's 1965, the Fair Housing Federal Act that we discussed earlier was 1968. We just did it sooner. Don't get confused by the date. There's a lot of similarity though with fair housing between state and federal. So the one key thing I pointed out to you that I want you to know for the state is that the original protected class was race. And then we've amended it and added to it over time.